morning. We'll call the meeting for the State Board of Optometry to order, please. First, we'd like to start, Madam Secretary, with roll call.
Okay, Ms. Brandvine.
Here.
Dr. Tretsky. Here. Ms. Michelin here. Dr. Chawla absent. Dr. Garcia. Oh, Ms. Garcia, you're a doctor. Ms. Garcia. Dr. Calgucci.
Here.
Dr. McIntyre.
Here.
Mr. Moradami.
Here.
Ms. Salazar-Sperber.
Here.
Dr. Wong.
Here.
We have quorum.
Thank you very much. Appreciate it. One quick comment and welcome. We met last night, one of our newest members of the Dispensing Optician Committee, and Adam Bentley joined us for the day in the meetings and then stayed after to meet some of the board members. So special welcome to, please reconvey to Adam. It was a pleasure to meet him and thank him for his public service. Thank you. Next, the public, speaking of which, any items that you would like to raise not on the agenda? Okay, hearing none, we'll go ahead and move to agenda item number 3, and I'll ask our administrative law judge to carry us through.
All right, good morning. I'm Administrative Law Judge Juliet Cox from the Office of Administrative Hearings, and I'll be conducting the hearing today on the petition for reinstatement, for early termination of probation, sorry. Are you ready, Madam Reporter? Okay, let's go on the record then. All right, I'm opening the hearing in the record in the matter of the petition for early termination of probation filed by Gregory L. Tom. This matter is Board of Optometry case number CC2103-47, and it's also Office of Administrative Hearings case number 2018-030793. Today's Friday, April 20, 2018, and we are at the Embassy Suites in Burlingame, California, at a regularly convened meeting of the Board of Optometry. I am Administrative Law Judge Juliet Cox from the State Office of Administrative Hearings, and I will be presiding over this hearing today. So let's begin with introductions by representatives of the parties, and I'll begin by asking the representative from the Attorney General's Office to introduce herself.
Thank you, Your Honor. Good morning. Anahita Crawford, Deputy Attorney General.
Good morning. And would you introduce yourself, please, sir?
Dr. Gregory Tom.
All right. Good morning, Dr. Tom. I understand you intend to represent yourself this morning?
Yes, ma'am.
Okay. Many people do represent themselves in hearings like this. Let me just give you a brief overview of how we'll proceed. The first thing I'll do is ask Ms. Crocker to offer us a copy of the petition that you have filed with its exhibits and any other documents that she proposes to have as the documentary record here of this hearing. She'll explain the circumstances of the case very briefly. Then I'll turn the floor over to you. You probably will wish to offer some testimony and some argument in support of your petition. You may have additional documentary evidence that you'd like to offer, and if you do, I'll mark it so that the board members may consider it. Make sure that you recall that the board has already had an opportunity to review the written materials that you've submitted, your petition and all of its supporting documents. And so the goal of your oral presentation today should be to highlight things that you'd like them to pay special attention to so that they might understand why you believe that they should terminate your probation before the date that it otherwise would terminate. There are a lot of other items on the agenda today, and so I'm going to impose an approximately 10-minute time limit on your presentation. When you've concluded your presentation, Ms. Crocker may have some questions she'd like you to answer, and the board members may as well have questions they'd like you to answer. In addition to you, if you have any other witnesses that you'd like to call, those people will be permitted to testify as well. I don't see anyone here in the hearing room, but if you have anyone, you'll be able to call them as well. When we conclude the presentation of evidence on your petition, that will conclude the open portion of the hearing. The board will then, in closed session, convene to consider what it's heard and to make a decision, which will be rendered later on in writing, not immediately today. All right? Does that make sense to you?
Yes.
All right, great. Then let's begin with Ms. Crocker. If you'd like to introduce the case to us, please.
Thanks, Your Honor. I would at this time like to mark the exhibits, if I may.
Yes.
Exhibit 1 is the notice of hearing of today's hearing date. Exhibit 2 is the certificate of license history for the petitioner. And Exhibit 3 actually contains the certification of license history for the petitioner, as well as his petition for early termination of probation. And Exhibit 4 contains all of the pleadings, orders that have been filed in this case, beginning with the accusation that was filed in 2007, from which this case originates. I'd like those marked and introduced at this time.
All right. They'll be marked as you have identified them as Exhibits 1 through 4. Dr. Tom, do you have any concerns? Have you had an opportunity to review the documents Ms. Crocker identified? Do you have any concerns about their accuracy or completeness? Any other objections to the board's considering them as overall the documentary evidence relating to your petition? All right, then Exhibits 1 through 4 will be admitted.
Thank you, Your Honor. As the exhibits indicate, an accusation was filed on March 26, 2007. And that accusation alleged that between 2001 and 2003, the petitioner submitted fraudulent or improper billing to VSP that totaled approximately $85,000. The audit that VSP did revealed that the petitioner had billed for lenses that were not provided, had provided Plano Gray 3 lenses when gray lenses when prescription lenses were ordered and billed for, inflated amounts billed for, and double billed for certain lenses, including double billing insurance plans, switching dates of service, changing patients' dates of birth to support the billing, and inflating frame costs, as well as overcharging patients for options and billing Plano sunglasses as frame only. On April 3rd of 2008, in response to the accusation, the petitioner surrendered his license and was ordered to pay $11,000 in costs for reinstatement. In 2010, the petitioner's license was reinstated on a 5-year probation term. The petitioner, approximately 11 months later, filed for a petition for early termination, and that was denied. On August 16th of 2011, it was on August 16th of 2011 that the petitioner's petition for reduction of penalty and early termination was denied. And his petition for reconsideration was also denied. The basis for this was that it was discovered that he had performed during the probationary period optometry services at a local college without first reporting the employment to the board. He was not supervised during the work as required by the board probation terms. And when he wrote checks to reimburse the colleges for the compensation he had received, he had written on the checks that they were donations. And this gave the board great concern that he was in fact seeking to derive a tax benefit by trying to correct a violation of his probation term. As a result, the board filed a petition for revocation, which was granted. On December 11th of 2013, respondent's license was reinstated based on his petition, and he was again placed on 5 years of probation. The requirements were that he identify a worksite monitor and that he take an ethics class and participate in community service and pass the law exam. On January of 2015, respondent filed a petition for early termination, and that was again denied. And the basis for that was that while he demonstrated remorsefulness, the board felt that the petitioner had such a history of being dishonest to the board that they didn't feel that he had properly rehabilitated in 2015. Therefore, in 2016, the petitioner again filed a petition for early termination, and that was again denied based on the history of probation violations and propensity for deception to the board. Approximately a year later, which would be today's hearing date, the respondent again filed a petition for early termination. He alternatively is requesting that the provisions requiring employer notification and worksite monitoring be removed and that the 16-hour volunteer work be deemed satisfied.
Thank you very much. All right, Dr. Tom, how would you like to proceed? Would you like to testify in this matter?
Yes.
And would you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you will give today will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Please go ahead.
Thank you, board members, Judge Cox, and the public for allowing me to present. Since you've already read my presentation, I'd just like to let you guys know what I've done and what's been happening for the last almost 4.5 years. I have been reminded every day about my actions in the past. And, you know, one of the things I'd like you to know is that I have been completely compliant with all of the terms of my probation. Even though the decision in the past was not to my favor, I embraced that. It was the board's decision to protect the public, and you know, I acknowledge that, and I've continued to better myself in my profession. You know, since then I've become glaucoma certified. I've also in the process of becoming board certified. So I value my profession a great deal. You know, some of the things, that highlights in the last 4 years, one of the things I was required to do was to contribute volunteer services, specifically optometry volunteer services. And that is really, really hard to do, even though you want to volunteer, because most places, I found out, don't want somebody on probation. They wouldn't let me volunteer. And so I became very creative, and I actually created an eye clinic in a very San Leandro, Oakland area where it was really, really needed. They didn't have it. They thought it would be a great idea. But they had no equipment and no funds. So I provided all of that, from the equipment to the stand, just to do a complete eye exam, tonometry, everything they needed. The drops, you know, the BIO, all the instruments I provided that were mine. And I've been doing that now for 4+ years. And in fact, just the other day, I was asked to participate on a weekend because another place heard about my services and wanted me to volunteer there. They said, your services would be really needed here. So, and I was required to do 16 hours a month. And, you know, from my letter, you can see I've more than exceeded that willingly. That's one thing. The other thing that I've also done is, you know, besides being in complete compliance and besides expanding my license, you know, I've also contributed things back to the community, like volunteering at schools to teach. I've participated in the STEM program where I've taught science and technology, and I did eye dissections for the students. You know, I've continued to take continuing education classes. I think it's really important to know that, you know, a lot of my time spent is trying to do and make the right decisions. And you can take, for example, the other day I was in clinic and a young gentleman presented with these swollen optic nerves, we call it papilledema. And I had a decision to make. The surgeon I worked for was sick, out of the office. I was there seeing the patient. He was young, he had no insurance. But we had to run these tests. So I made the decision to run these tests to make sure of it. But he couldn't afford it. So I made the decision for the office, decided to waive the charges. Then I had to decide what was his best interest. Do I send him to his neuro-ophthalmologist where it's going to cost him an arm and a leg? Do I send him to the internist or I send him to the ER? What would be the best way to go? If he goes to the ER, it's probably best for him economically, but it would take a lot of work on my part because I'd have to follow up with him, try to find who the ER physician was. It turned out we probably saved his life because his blood pressure was like 240 over 150. And I had to track him down. We talked about it. And there was a good example of making a good medical, ethical, and a financial decision in the best interest of the patient. But I didn't hesitate to make that decision. The staff was like, are you sure the owner's going to get upset? I go, we need to do this. So I think I can make those decisions unwaveringly now. You know, if you look at some of the letters of recommendation that came with my file. One came from Dr. Hermatsu from Rotocare. That was the clinic, the free clinic that I created the eye clinic for. And, you know, she can tell you that I've definitely volunteered more than my time and made a big service to the community there. You can look at the letter from, Judge Woods, who's a Superior Court judge, who was actually at my hearings in previous. And he sees rehab all the time, and he's even testified that I would be a good benefit to the public. And, Dr. Steinberg, who's also an attorney and optometrist, he's also vouched for my character, and he's known me. So these people have actually not just written letters, but they've actually seen me progress for the last, I'd say, more than 7 years. So, another thing that's, I think, important that was brought up by the board in the past too is because of my billing past, I've also tried to take some seminars on billing. And if you look at the thing, I've taken probably 4 or 5 classes related to billing procedures and new codes that are now in place. And in fact, in the office, we just had a billing class, and I was the one who was helping a lot of the staff properly bill and not overbill on what they couldn't bill for. I've taken all my ethical classes. I've even completed this year's in advance, even before it's due. I think if you look at the past 4 years, you could always say, well, this is what he said he would do. This is what he wrote on paper. But a lot of times, actions speak louder than words. And if you look at all the things I've done for the last 4+ years, that really shows you that I've met the conditions, I met them willingly, I exceeded them. Rehabilitation is the process of returning something to a previously good state. I think for the past 4 years, if you look at the things that the board's been concentrating on, my actions should help prove some of the trust, to reinstore that in you, and to show how honest that I've been. I made a promise to the board, and I think I've honored that promise for the last 4+ years. I've shown the respect and patience. This has been a long journey for me and my family. And, I think I've clearly shown that you should consider this. I ask with great sincerity that the board consider my petition for determination, not because of words, but because of the actions. I don't think that the risk to the public exists any longer, and I think my actions show that. I think I've proven to be trustworthy and honest. I'd like the board to carefully consider what I've proven to you in the last 4 years, and not the previous, but what has happened now and what I've accomplished. And I still have a long road to continue. Finding work is really hard on probation. I even told the board in my letter that even if you granted my early termination, I would still continue with my volunteer optometry work. I do really enjoy it. I want to thank you for your time and allowing me to present and give you an idea of the person I am now and where I've come from and what I've done to try and earn your trust. Thank you.
Thank you. Ms. Crocker, do you have any questions that you would like Dr. Tom to answer?
Yes, I do. Dr. Tom, during your presentation, you referenced an example for the board of when you made a good ethical decision.
Yes.
And I just wanted to explore that situation from the beginning. Can you tell me what the patient was being seen for in your office?
Gradual loss of vision.
Okay. And what was the next step you took after determining what the reason was for him visiting your office?
So after I diagnosed him with the medical condition, there were certain tests I needed to run photographs to document for legal reasons. And then while those were being done, I then had to decide, where do I send him? I had to find out about, did he have insurance? And then I had to listen to the patient, and the patient was partially speaking English in another language. He had his family with him, a younger brother, who was translating some of it. And the impression I kept getting was, how much is this going to cost? I'm not working, I just want to see better. And so, being in private practice, which I'd been previously, and now working in a surgical office, I had to make a decision to try and do what was in the patient's best interest, at the same time protecting the office, while seeing other patients determine where he should go. I was on the phone to other local ophthalmologists who were on call. Nobody answered. So now I was stuck with another predicament. And after consulting with some other friends I had known, it was decided that, hey, this is where he should go. The county would be best. They could probably get him on a Medi-Cal plan or something and do the test. But if not, I think by law, we have to take care of patients if they present in a public hospital, regardless of the ability to afford it or not. And in his condition, it turned out to be probably a life-saving one because of his blood pressure. I'm not sure if that answered I hope that answered your question.
It does, and I can ask some clarifying questions.
Sure.
So you keep mentioning that you had to decide where he should go. What was happening where you needed to decide where you determined he can't receive further treatment from you?
Because it was beyond my scope of practice and
Okay.
the office scope of practice. The office I work is secondary care, which means, primary care is what somebody will come in to screen, whether they need glasses. Oh, we have a condition. Well, then that goes to another specialist. Well, this was beyond the ophthalmology clinic that I was in. It was beyond their specialist. It was an emergency because he was losing sight. He was bleeding internally in his eye. And when you have this condition, the differential diagnosis is tumor, infection, increased intracranial spinal fluid, something like that, or something that causes that. Well, that would be beyond me. That would be to a neuro-ophthalmologist, a neurologist, which would be very, very costly, not only time consuming for him, and then now his blood pressure would probably go up even more because he's very stressed. So that was the decision to make, to get him to the county ER hospital.
Okay, so you knew that he needed immediate care, and you were calling around to find out what would be most beneficial to him financially and also provide him with that care.
Not necessarily, yes. Yeah, I guess you could summarize it as that. What would be the best care for him at the same time considering his situation, so I wouldn't put him in a worse situation, and what would be best care for, time-wise too, because there was a time essence issue.
Okay. And you said you also waived his fees for the
Well,
office?
the other tests were done, yeah, because I wanted to document, because the surgeon wasn't there, and there was nobody else to refer to, so you want to document anytime you see something as best you can. Well, those things cost quite a bit, and reluctantly, he didn't want to do it. I just said it needs to be done in case we need to send it forward. And I just said, we'll waive these charges. I told the staff and the administrators to waive the charges for him, and I think that was the best interest of the patient overall.
And had you first consulted with the owner of the clinic to determine if that was something that they were okay with?
He was unavailable,
Okay.
but it was the best interest of the patient. That was the key. I wasn't going to have the patient wait in the office and worry about another $300 worth of charges when he needed to go out, right? And a lot of times when you go somewhere, it's like buying gas or something. You can't really get the gas and go. You have to pay for it at the time. And so rather than, that just meant the patient was more important than the economics of the office, in my opinion. And if it really came down to it, and he really, really debated on it and really wanted it, honestly, I would just pay for it for him if it really came to that, because, in this case, it would have saved his life.
Thank you. The main concern for the board and the basis for denying your petitions in the past has had to do with a lack of honesty. Can you explain, and I know you've already done this in question number 13 of your application, but could you explain in your own words why the accusation was filed and you were placed on, a discipline was taken and you were placed on probation?
Okay, so in the presentation, the facts are correct. I did actually volunteer at these, work at these colleges without telling my probation monitor, who at the time was Jessica Sieferman.
I'm sorry to interrupt you. I meant the original accusation. What is your understanding of what the original accusation
Oh, from
alleged?
2002.
From 2007. Yes, the incidents in 2002, the accusation was filed in 2007.
Yes. So the action was, she is accurate in that there were office misbillings, so they were overbilled patients. And exactly it's described, there were patients that were, I can still remember it. It's hard to the public to understand this, but if there are reasons why insurances changed, patients sometimes weren't benefited by it. They were benefits were taken away. I unfortunately made the decision to take matters into my own hand and go, oh, well, this will benefit the patient. We'll do it this way. They changed the requirements, and so I figured a way to get them to have the requirements. It benefited the patient, yes. Did it benefit the office? Yes. Was it wrong? Yes. So I don't argue that those accusations were incorrect. I do support that they were wrong, and they should have been done. And were all of them under my watch? Yes, because I own the office. Should I have prevented them by having procedures in place if I was to return to private practice? The answer would be yes. Many of you doctors know it's very hard to look at everything in your office in a busy day. However, the owners are still in the bottom, in the end, accountable for everybody that you hire, right or wrong. It is the responsibility to know all those details. So I made that mistake, and I continue to make it, which led me down this road, and now I'm trying to make amends. If I do go back into private practice, I will still have to go down that road again, because I will have to petition to be back on those plans and prove to them that I won't make that mistake again also. Does that answer your question?
It does, thank you. I have no other questions.
All right. I'd like to invite the board members to ask questions as well. And I think we'll just go around the room. I apologize, I can't see some of the name tags that are facing me, but why don't we begin with Dr. McIntyre? Do you have any questions for the petitioner?
Not at this time.
All right. Ms. Garcia, do you have any questions for the
Not at
petitioner?
this time.
All right.
Dr. Tom, how do you know Judge Woods? You've submitted his letter of recommendation a couple times.
I've known Judge Wood since I was a freshman in college. And so we have grown up together. And from that, when we met very, very early, and we've been in touch since as we both progressed in our professions. So he's a good example of a person who's known me, obviously longer than 4 or 5 years.
So you've known him before he was a judge, then?
Oh, yes, college. I mean, we were 17 years old.
Oh, I don't know how old he is. So if the board were to grant early termination of probation, what are your possible career plans from then on?
Well, it would be helpful to me at my current work because to be very blunt, when you work in any private practice, you have to be, DSP is the largest insurance company in the world, basically, in the United States. You need to be on their panel. So what work I can do is very limited. Even though I have all the skills and probably as good as the best out there, drug-wise and everything else-wise, diagnostic-wise, I will have other doctors hired who have no experience because they get on insurance panels. So my job ability to work is really limited. I also can't work in a commercial setting. So for example, even at Kaiser, I'm not allowed to work there because I have to be monitored. So it would allow me to basically move on with my life and start over. I mean, it's been, since 2002, it's been 16 years. It's been a really long time. I mean, and so I've been through it once, made a mistake, made another mistake. Now I haven't made the mistake. I'd like to start over. I'm still relatively young. I'd like to practice another 20 years and, help more people. I hope that answers your question.
It does, thank you.
Thank you.
Any further questions?
No.
All right, Madam Secretary, any questions?
No questions.
All right, any questions?
No
sir?
questions at this time.
All right,
No questions.
Dr. Hart?
No questions.
Ms. Berber?
No questions.
All right, any questions from the chair?
No questions, thank you.
All right, then, thank you very much. Do you have anything further to say to follow up on any of the questions that have been asked of you?
I just like to remind the board that it doesn't always matter what I say, it's what I've done. So if you can just look at the actions, that should help the board, because the board has to make its decision based on what you feel makes somebody safe to return. If you set a criteria, I think I've met or exceeded that criteria, and proving that, I can be an asset, not a hindrance. Thank you.
Thank you. Will you be presenting any other witnesses today?
No, I will not be.
Okay. Ms. Crocker, is there anything that you'd like to say in summary?
Yes, Your Honor. In closing, the concern for the board in this case has always been petitioner's honesty and whether he can be trusted to make proper ethical decisions pertaining to financial decisions. And the petitioner today did testify and provide an example of when he placed the best interests of the patient first. And that did involve some decision making regarding the financial obligations that patient would incur, and attempted to do what was best for the patient. I will leave that to the board members to determine if that decision was appropriate to make for an individual in that situation. But when I did ask the petitioner to explain the reason that the accusation was filed in the first place, it was very similar to what he stated, what he provided today as an example of his good ethical decision, which was he was acting in the best interests of the patient and trying to provide the patient with the most care he could provide, but in doing that, he was dishonest with VSP. I think that needs to be looked at further, because that in fact is not what the basis of the accusation was. The accusation wasn't that the patients were benefiting, as the petitioner states in his response to question number 13. He indicates that he was taking certain actions in order to help his patients, and that the patients benefited from the actions that he took, even though his actions were foolish and irresponsible. He also mentions that the audits, which resulted in the overbilling discovery, accounted for less than 0.1% of the number of yearly exams that he had performed. But the evidence has shown, and is indicated on page 4 of the 2016 decision, that the audit revealed that it was 67% of the entirety of the files reviewed and 80% of the files reviewed from a second office that revealed these inappropriate billings, and that the patients were billed for items that they never received, or that they received inferior products. So it is inconsistent still today with his testimony and presentation that the patients benefited in some manner, that this was a Robin Hood type act on his part to overbill or bill VSP in order to provide for his patients. In fact, that was not the case. And What I heard today was a similar tenor to what has been stated in the past. While Dr. Tom speaks to his clinical skills, that has really never been the cause of this accusation. It has been his honesty. I would encourage the board, it would be our position that this petition should be denied. If the board is inclined to modify the petition, then I would agree with Dr. Tom's request that the terms be modified to permit him the opportunity of working without a worksite monitor, which would also provide him the opportunity to bill for his own patients and still have the board oversight and guidance in that new endeavor. Simply, Your Honor.
Thank you. Dr. Tom, do you have any final summary?
I don't think anything changes from my presentation. I think there's a misunderstanding on the facts. I don't disagree with anything that has happened in the past that was done incorrectly. It was done incorrectly. The one thing that she did say, the percentages of 1%, that was based on the total number of overall things that were done in the office, not, it's been a long time. I mean, those numbers are from 2002, but I think the main thing I want to leave with the board is that people change over time. As we get older, we change. Hopefully we learn from it. I think I learned from it. My actions clearly show it. What was done in 2002 was wrong. But from the last 4 or 5 years, 4.5 years on my probation, I think I've proven that people can change.
All right, that will conclude the evidentiary portion of this hearing. The board will now move into a closed session so that it can consider in private the information that it has heard and deliberate about the outcome. Thank you very much for your presentations, and we'll go on. So I don't know all the people here. I'm not sure.
We're now moving into closed session. Everybody seated? Okay, we'll call ourselves back into open session. Thank you all. I would like to recognize two who joined the table. Jessica Sieferman, our executive officer, and Rob Stephanopoulos is here, and Todd Kieran from board staff. So thank you for joining us now in the open session. So let's move on to the president's report.
Minutes. You want to do the minutes first?
Well, we've got 10 minutes before we're
That's up to you.
moving into, we can just stay in order, and then we'll go to the minutes.
All right.
So, President's report. First of all, you've noticed that the letter has been going up each month, sometimes the first, sometimes middle of the month, but it's getting there, and the President's message. So we've been covering a variety of topics, good, bad, and different. Okay, so I'm not going to go through the topics that have already been discussed there, but I would like to bring up that our EO is asking us to consider how we stage our committee meetings. We originally had committee meetings happening at a variety of different times whenever the committee chairs called the meetings. And we moved to a set time on a set day to be really efficient, approximately 1 month before board meetings, in order to act upon what the committees did, and so that we would have fruitful discussions during the board meetings. Staff is coming to us today for us to reconsider the posturing of those meetings to the day before the actual board meeting itself. And there are pros and cons to both sides. The board staff would like us to consider their workload, and we all then as volunteers need to consider such things as the doctor's taking an extra day off from seeing patients, the travel time that's in there, which typically impacts the day prior anyhow, and then the board meeting itself. So I'm going to open that up for discussion, and then we'll see how we're going to shape or reshape. So Dr. McIntyre, anything to add on committee meeting dates or times?
I'm torn. I'll make it work either way, but I don't like teleconference meetings. I'm much better when I can see faces and get a feel for it. So I feel it's more interactive for me to be in person, but then there are the logistical issues that you mentioned. But I'll defer to other comments on this. I will make it work either way.
Ms. Garcia?
So these these are face-to-face meetings that are scheduled?
Yeah, so the idea would be they would be in person the day before the board meeting, and so it would incur the same kind of travel costs because you're going to the board meeting already and everybody's going to be there. And then the other benefit of having all the members there and with the president as well is she'd be able to go and listen in on the committees to kind of keep apprised as it's happening of what's going on. So there's the benefit to having everybody in the same room.
I think it works, especially for the DOC. It worked this time around. So I like it.
Mr. Murdomi?
A question about, for example, lodging. Is that going to increase the lodging expense as part of that travel expense for an extra night?
Yeah, so potentially, depending on when we start, you could have another night of a hotel room, or if we time it correctly, if we time it later in the day, then we might be able to. So it's just still one hotel room. So it's one hotel room. They meet the day before, and maybe the first meeting doesn't start until 10. So it gives enough time for people to get to the meetings, and we only incur one hotel room and one set of travel costs.
That can be a little bit difficult if someone's coming from a long distance and they're flying out at 4 in the morning or something, and they're not at their best when they come to a meeting. I can
You
see
don't
myself.
like waking up at 4 o'clock in the morning?
Sleep knows that is sleeping in late, so.
I'm not sure I like it, but purely for personal and selfish reasons. And I'll just, usually I have things that I need to do on a Thursday night in town. So I would have to do something about my schedule. I also personally like, having a meeting, having a series of committee meetings, and it might take 2-3 hours, but I can go back to my office and keep working. So it only takes a few hours out of my day, as opposed to spending an entire day at a face-to-face meeting. So it does require more of a commitment on my part. I am wondering whether or not, is there any flexibility in that if we do indeed have a face-to-face meeting, can we, we do this anyway, can I participate by phone to the face-to-face meeting? It kind of defeats some of the purposes, but, is that an option?
Ms. Michelin?
I kind of agree. I have another question. If we do this, and let's say like Reg Committee, are we going to get, you can't discuss it at the next day because it hasn't been noticed? If something comes up at a committee meeting, at least we have time to notice it so that we can bring it before the full board. And especially when you're talking about legislation, it's constantly moving. I can anticipate problems where, we can't talk about it because it was happening the day before and it wasn't on the agenda. The other issues, I agree. I'm just going to be selfish. I'm volunteering my time, and that's 3 days now I'm taking off. And I'm with you. I also have kids, so that means my husband travels. That means I'm incurring personal costs to get someone to watch my kids when I'm coming to volunteer my time. I think the system's working. I mean, I like it. I think there's enough time that if things come up at a committee hearing, we can address it. You know, so I'm not a fan.
Dr. Turetsky.
Question for the executive officer. If we were to do this back-to-back, Thursday, Friday, is there anything which prevents us from doing the committee meetings later in the day? The committee meetings, usually we're looking at a total of 4 to 5 hours. Could we start something like that at 4 o'clock or 5 o'clock and run till 9 or 10 o'clock? Not, that's what I'm just wondering, if there's a way of doing that instead of starting at 9 in the morning. So that way you're eliminating an overnight stay and people could fly in and then attend the meeting that way.
So, yeah, that's a potential, and if that's what the members would want to do, we can look at doing that. Because when we travel for board meetings anyway, like Rob and I don't get overtime, so it's not an issue for us. It's but when
So you can work till 10.
so it doesn't really impact us and when Todd travels with us to meetings, he's still getting overtime for that, so it doesn't really impact as far as the state time for that. So it's definitely possible to do.
What about members of the public? If you want to open it up to the members of the public, come to a Ledge Ridge committee at 9 p.m. I mean, I get what you're trying to do, but I'm like,
I'm open to anything
you
unless
know,
my schedule can be adjusted.
huh? I mean, I guess my point is we still, part of doing these committee meetings is, you know, is also being accessible to the public. And, you know,
It might be more accessibility to the public, so somebody like Dr. G, who's here today to testify, he could do this after work. So it does.
but then you're not going to be able to do all committee meetings at which I mean, how are you going to do that? I'm sorry, I'm just asking logistically, how are you going to have public relations?
Oh, I know.
You know, so
I'm just bringing up
I
an
know,
alternative.
I get it.
But I'm fine either way.
Dr. Wallen.
I'm torn. I'm so short, you can't see me. Thanks, Rachel.
I know you were there, that's why I'm like, what?
I'm just underneath the table today.
I'm blocking it.
Oh, I'm torn. I mean, I'm like Deborah. I would prefer to have the meetings in public, but I have kids too, and I don't know, the logistics of not being there Thursday afternoon, or all day Thursday, all day Friday, it's an issue. I mean, I'll make it work either way, so.
Thank you, Dr. Kawaguchi.
There are definitely pros and cons either way. From a personal standpoint, it would work right now, but typically having to have 2 days back to back away from work would be a hardship. Having it spread out, I think, offers benefits where, to Rachel's point, the committees can put together information, it can make it to the next meeting because we have the time to do that. If we have committee meetings the day before our meeting, I don't think it's going to translate. It won't give the committees a fair enough amount of time to put together the information to bring to the next meeting, which is the next day. So then probably what will happen is the information will not make it until the next quarter's meeting. Or we'll have to call a special meeting. So we might end up increasing our workload by trying to put it back to back. So I don't feel like there's a major problem with the way that we have it. So my feeling is to keep it as is for now. But I do appreciate the thought because there's pros and cons either way.
Ms. Salazar-Sperber.
I actually, it doesn't affect me in the same way as a hardship because I can work remotely, so I can work around whatever schedule, you know, comes about. And I do like that at least if we're doing back-to-back, the calendar is set so that you do have ample time to make arrangements for work, kids, life. So I would encourage, you know, having the calendar, you know, I like the predictability of it. And actually, I might be the only one here, but sometimes those committee meetings on a separate day are actually harder for me to attend. So.
Sid, I had one more
Yes.
comment, and that is, and I discussed out of pure curiosity with the executive director saying, let me know if my committee meetings are an additional burden to the staff, because perhaps for the Consumer Protection Committee, maybe we don't have to meet. Maybe you don't have to make a presentation to us and go through that process. It depends on the issue. And I get it, the ledge reg has to meet because there's a lot of thinking going on. But if there are committees that don't have to meet, is that a way of kind of easing the burden on staff so you don't have to present something twice? And I'm flexible in regard to the committees that I am on. It depends on the issue. So
I was going to suggest that we hear from the public, and the public just stepped out for a moment. And Ms. Alzar-Sperber needs to step out for a meeting. Any comments from the public on this topic of committee meetings and dates and times? And then my question is, do we want a motion on this for a board handbook, or
Well,
I
I
think I'm a tiebreaker?
I want Nina to answer the question though,
Which one?
which is noticing anything that, like, particularly I think more so for ledge reg. I mean, if we have a ledge reg committee meeting the day before and something comes up,
Unless it's 10 days before the meeting.
so we can't
Right.
discuss it.
You wouldn't be able
So
to, unless
that-
it's within
Yeah.
a category that's already been
So
noticed.
to Glenn's
But that would still
point,
happen.
so
If
to
something
Glenn's
happens the day
point,
before.
Right.
the board
then
meeting.
you're pushing something back a whole nother 3 months until we have a quarterly meeting, or we end up having to do a special conference call, which then, we're not,
And I think what Jessica's saying is that would happen if you didn't have the meeting. If something came up, 2 days ago, you wouldn't be able to
no,
talk
but
about
I
it.
would
but-
argue that when we've had like reg committee meetings, there have been opportunities where things can come up and we could say, okay, we might not be able to discuss it with ledge reg, so let's put it on the agenda so that the full board, because regardless of what we do, it all has to go through the full board, right? We can't make a decision and move forward without the full board. So I think in the case of, because then are you also going to have practice and education the same?
Everything. And who's to say too that you'll be able to complete the business within that day prior? Does that mean the RDOs need to have the same day, would be having concurrent meetings? Now how do we start splitting people up to decide what meetings they're going to or not going to?
Well, but the DOC, where I'm the only one who's part of the board.
But
But
that
your
works,
staff-
limits, then that
Limits
pulls you
from the
off.
other, yeah.
That basically pulls you off other
The other
committees.
Yeah, you won't be able to be on anything.
Yeah, that's
I appreciate the sentiment. I'm glad we're having this discussion. I like the creativity. I appreciate that the board chair has engaged the board members in the committee work to get us more involved and to actually put us to work, which is helpful. I don't see the committees should be doing, actual productive work. We should not be, more oversight over the staff. So the committee should be run so that we help the staff do their work and provide input. If we're not doing that, then we should not be having the meeting. So it's, just tell us how we can help you guys do the work without just doing things over and over again. So I make that offer. You don't have to answer that now, but I just make that offer in terms of how to address this issue.
Okay. So the question is, would we like to take a vote, or would you like the president to weigh in and provide some guidance on the path forward?
I think we should see logistically, I want to know logistically how it's going to work. I mean, what are the times? I mean, to your point, are we going to cut off? I mean, we got through ledge reg by, but we've got a ton of stuff. I mean, if we're talking about branch licensing, mobile clinic, children's vision, whatever else, and that's just now, right? We don't even know what else could pop up. I mean, I'm speaking from that perspective. I mean, I'll be honest, I would then ask to not be on other committees because I don't have the time. I just don't have the time. This makes it harder for me to fully participate.
I'd like to recommend that we keep the status quo, and that, to Mr. Moridomi's point, if there's an opportunity to help work through this extra work, because that's what I'm hearing, what does that mean, the extra work? Understand that better and see if we can help with some workload issues here, if that's the underlying. I am concerned that things will get delayed, and in prior years, we've had that, where we had to lose 3 whole months on pretty significant topics. So this gives us an opportunity to keep the agenda moving and to provide consumers with really timely decision-making. Anyone want to object to that we take a look at how to best maybe adjust staff workload? And then we can revisit this again, even at the next meeting or meeting thereafter, but I'm recommending we keep things status quo.
I have a question.
Sure.
It's for the DCA. Hi. I think I know the answer, but there's no video conferencing capability at the state of California, is there? Within Department of Consumer Affairs.
Communications team.
Not WebEx, like a room where
Google Hangouts.
Google Hangout, where we can go and there's a big screen and we can do video conferencing, not WebEx, because WebEx doesn't always work, but where we can better be able, to your point, having that face-to-face. Sometimes WebEx doesn't work that well. Sometimes on your computer, it depends on your internet connection. Kind of what we did at the college with Ruby.
Yes. And if you could, hello, Chris.
Yeah, that was.
Sorry, sorry.
Absolutely. Yeah.
We don't have that though.
Yeah.
We don't have access to that.
He's going to introduce himself.
Sorry.
Chris Estrio, Department of Consumer Affairs. So, don't mean to hide behind the fact that I've been here for 6 months. I haven't seen that during the time that I've been here. That being said, I would imagine through either our comms team or our Office of Information Services, I can certainly take that back and see what sort of capabilities or options that we might have. Can't tell you definitively either way. I just can note that I have not seen, I guess, a centralized service sort of face peer-to-peer calling or video calling that we've offered. Doesn't necessarily mean that it either doesn't exist or that it possibly could exist. But I would need to bring that back and check with our team.
Because it would benefit other boards.
Yeah, I see
We're
what
not
that-
the first board
Yeah,
that has
sure.
this problem.
Sure.
Yeah, and that would be good to research that. I know that at Moore Park, just with my class, we did a video conference with a vendor over in New York, and it worked out great. It was on the screen. It was really, really nice. And I know it was set up in Sacramento. I'm sure we have other locations where it's set up.
Yep.
That'd be great.
Yep. Take that back, and then of course also check with our legal team in terms of making sure, right, we're talking about open and public meetings as well. So all those capabilities that they're offered to the public as well. Okay.
Great.
Thank you. Appreciate that. Dr. Kawaguchi.
So I have a separate comment slash request from our executive officers on the board. So about the workload that it takes to prepare for meetings. One of the things that I appreciate about our staff is that they say yes. When we ask for something, they say yes. However, sometimes I don't believe that we as board members understand the cost of that ask. And so I think it's going to be important as well that you and Dave work with staff to make sure that committee work stays on track with our overarching plan. And if it doesn't, for you to just be able to get back to the committees and saying, hey, so I know that you requested this work, however, these are the reasons why it's going to need to wait. I think we'd be okay with that. We'd appreciate that, because sometimes I get the sense that we're having to try to self-monitor ourselves, because it is inappropriate for staff to say no necessarily to the board. However, I think there's realities that we have to work through sometimes. And so I think that's a communication opportunity that we need to work through. as opposed to actually changing how we structure the community meetings.
Perhaps if the committee chairs could connect with me after their meetings. I know we tried in a written format, but maybe just a quick phone call and go through those top 3 items on your agenda and what you're looking for in the way of support or suggestions of the path forward for the next meeting, what have you. We can knock that out pretty quickly in a 10-minute call. And that's only a quarter. So then I can then help guide staff with respect to workload.
Or Jessica, when we have committee meetings and we ask staff to look into things, you have a general idea of how much work a lot of these.
Mm-hmm.
Maybe you could, at the time of the call, say, oh, we can look into it, but that's probably going to require X number of meetings, or it might take weeks, as opposed to that's like a quick thing that I can look up. And I think that would give all committee members a better idea of exactly how much work we're asking of you and staff.
Okay, thank you. Now we'll go back to the next agenda item, which is, as long as I put my trust.
So are the dates in here, those are the dates for the board meetings?
Those are the board meeting dates.
Okay.
Have they been published yet?
No, we wanted the board members to say if they had any conflicts or if it wasn't going to work, then before publishing.
So I had a request, and this is purely a personal reason. The April date, can we put it off by 1 week? Sorry, I can't. It's April 12th is the one that's being suggested right now. And I was wondering if we could do April 19th. And that's only because I'm
I'm
in town.
gone.
You're gone out
That's my
April
kids'
19th.
spring. We're going out to build houses in Mexico.
How about April 5th?
That's fine.
Does that work for anybody or not work for anyone here?
I'll just need to look at that. If I can look at the break, that would be great.
I have my spring break planned. I only have 2 more left with my son before he goes to college, so I have everything planned.
So the April meeting is the only one in
Oh, wait,
question.
on April, August, let me check.
Okay, otherwise we're looking pretty good. So either the 5th or I just closed it.
By the end of April? 26th.
Okay, we will take a look at that then. Thank you. Thank you. All right, thank you all very much. And for now, they'll all be adopted pending the April, and we'll get back to the board here very soon, maybe before end of day today. How's that? Okay, thank you. Now we'll move on to our next agenda item. Approval of the board meeting minutes, Madam Secretary.
Before you are the meeting minutes from the last board meeting. I'm looking for a motion to approve.
I'll move with one amendment. There's a typo. I think in spelling the word purview, it's spelled preview, or something close to that. So.
If you could do a word search, Jessica, that would be fabulous. Any other amendments that we'd like to see to the minutes? Okay, so we had a motion.
Wait a second.
I'll second it.
Thank you. All those in favor? That's right, sorry. Coming out of closed session, go right ahead.
Ms. Brandbein.
Aye.
Dr. Turetsky.
Aye.
Ms. Michelin. Aye. Dr. Chal is absent. Ms. Garcia.
Aye.
Dr. Calducci.
Aye.
Dr. McIntyre.
Am I allowed to approve, given I wasn't at that meeting?
Didn't we say you can read it? and-
Yeah, did you read it and you could abstain?
I'm going to abstain. Thank you.
Mr. Marnawi.
Aye.
And Ms. Salazar, she's not here.
She's out.
And Dr. Wong.
Aye. Okay,
It passes.
motion carries. All right, thank you. All right, the executive officers report.
Do you want to jump to SB 1386 since we had a time certain at 11?
Are they here?
Yes.
Yeah.
Okay, great.
Okay.
I was waiting for the
Sorry. Yeah.
sign. Okay.
So, members, before you, we're taking this item out of order to discuss SB 1386, and the reason being is we invited a board member from COA to come and address the board and speak regarding their position on the board's request to repeal the branch office license. I've been providing you updates as closely as they happen as possible, and they change very quickly. As you recall, the board had requested to repeal the statute. So since then, there's been several meetings with stakeholders, and the bill was amended last night. And the analysis was also published, and I provided that to all the members online. As you noticed too, this is not a board-sponsored bill. This is an author-sponsored bill. I spoke with the author's office this morning, and that wasn't any as a result of anything the board did or didn't do. It was more that the author's preference is to primarily sponsor his own bills. They are looking to get support from the board and a commitment to work with the author's office and stakeholders going forward. They're committed to this issue. It's my understanding, and COA can speak to it as well, from what the author's office told me today, is that they're planning on doing a statement with COA saying they're willing to work on this issue together to come up with a solution that's best for patients. So before you, the SB 1386 right now, it does repeal the requirement to obtain a branch office license through the board, but it does, it broadens the amount of offices that they can own. So right now it put a cap on to 12 offices. And it also provided additional consumer protection mechanisms to hold the business owner accountable if substandard care happened out of the person's office. So that's where we stand on this bill right now. There was a letter of opposition that I provided to you that I received early this morning from National Vision and Foresight. And from my understanding is they have concerns related to Section 5, which is the 17200 action. The concern is that it's overly broad and it could open up to a lot of unnecessary litigation and spend a lot of time in kind of some civil lawsuits and open it up. And I think they have concerns with that. I think they are willing to still work with the author's office, work with the board and stakeholders to still address this issue. So I'm not hearing from anyone that they want it to completely go away. I'm hearing that we want to work through it with the stakeholders and get a solution. As far as the limit to the 12 offices, I'm not sure what that does on the implementation standpoint for enforcement as far as what that actually gets us for consumer protection. But I think too, at some point, it depends on what the board is willing to do. If you want to take a support and work through it with the committee, or if this is something where you're opposed to, I think that's really a conversation with the board. So with that, I wanted to invite COA to come up and speak to their position. I do want to say that they invited us to their Ledge Lobby Day on Wednesday, and we participated. It was a great opportunity for us to speak with licensees about Breeze and the board and what we're doing. But they also did speak to SB 1386 and why they are opposing the bill.
Thank you. Thanks for having me. My name's Christopher G. I practice in Dublin, and I am a relatively new trustee on the Board of Trustees for the COA. So thanks for inviting me to come share the COA's perspective on the issue. The branch office law is not, in our opinion, just a relic of the past. It continues to serve a real purpose because it encourages patient care as our primary focus, and it relegates profit making as secondary. We all know that healthcare is changing and consolidation is happening in all sectors. We're concerned that a full repeal of branch office law will only hasten the trend towards consolidation in the optometric profession. Consolidation and the business pressures that often result from it can threaten the quality of care delivered. So the COA believes it's necessary for there to be some kind of doctor involvement or supervision over the practice they own. It shouldn't just be an investment interest. There are documented cases of optometric chain stores that have shortened the time optometrists can spend with each patient so that they can sell more products. In many cases, these stores were managed by other optometrists. If we open up the law to encourage this practice modality, these same problems will reappear. Remember, the Attorney General initially took action against chain stores in California decades ago because a patient actually was blinded. A total repeal of branch office law could have a dramatic impact on optometry's practice. We accept there's room for change, especially if it allows group practices to better serve underserved communities. But the COA is in support of more incremental change. Why not replace the 2-office limit to a 5-office limit, and then evaluate the impact of this change at the board's next sunset review? If you do not see an increase in complaints to the board, then we can revisit the law again, perhaps expand it even further. The issue goes to the heart of what optometry really is. We want to ensure it continues as a primary healthcare profession and not go back to a profession of spectacle peddlers. And this is a big change, and we ought to take the time to get it right. Thank you.
Okay, comments and discussions, questions for our colleagues from COA. Dr. McIntyre?
No, at this time.
Ms. Garcia? No. Mr. Morodomi?
Will the amendments that we received this morning, or will the bill that we received this morning and/or the bill as COA envisions it, what effect does it have on the ability of an optometrist to make a house call? Or will it have no effect?
I don't think it has any effect on the house call issue.
Thank you.
It's a whole nother discussion.
Yeah, I get it. As you know, I've been interested. I want to check.
I know.
Just want to check.
Ms. Michelin?
So, is it your position that you would prefer that we don't even touch the branch license issue at all?
I think from our perspective, Christine Schultz again, representing the California Optometric Association, from our perspective, I think that we see that there is a need for change, but what we really want is a go slow approach. I mean, there's a lot of nuances to this issue as we're finding out as we work through the amendments. And it could have some real impact. And it's easy to get around. Workarounds are possible, and we're trying to make sure that that doesn't happen. And yeah, I think we would prefer to have an approach where we all sit down, all the interested parties, and work out something that makes sense, and that we can make sure is enforceable. At this point, we have an opposed unless amended position on the bill as it's in print now.
The new one that we just...
Even the new one. We're looking for 5 offices, and we have some concerns about some of the other language that's in there now.
Do you know what some of your concerns are with the new stuff that we just saw this morning?
Yeah, I think we're still concerned about the new reporting requirements in the bill. The reporting requirements, I think that's onerous, quite frankly, and it applies pretty much all optometrists who own a practice have a 15% interest in those practices. So that applies to every optometrist. So we have some concerns about the way that this bill would be implemented.
And then to your point, so help me understand, because I'm not an optometrist. So right now, if I have a license, I can basically have 2 branches. Because I have to be there 50% of the time, correct?
Per the definition now, neither of those 2 offices would be considered a branch office. They'd just be your offices.
Okay.
Once you start to open a 3rd office, that would be your first branch office, and that's what you would have to notify the board and get approval for.
And currently, how many branch offices can I have?
Unlimited. However, for each branch office, there are rules in place regarding how many hours a week that office can be open based on how many hours you as the owning doctor are there practicing.
So I can't say I'm going to open 10 offices and hire 10 optometrists to work in those offices if I'm not there a certain number of times, a certain number of hours, correct? So part of my concern is also access to care. We know there are parts of the state where there is no access. We've had testimony before our committee on children's vision where, wasn't it Glenn County? I forget, I'm looking at Glenn. Wasn't it, there's one county where there's 3 optometrists in the entire county. How, I would prefer to see more opportunities if optometrists want to have a different business model to provide access to care. How do we meld that together? Because I kind of look at this as, you know, let's say I'm an optometrist and I'm in Bel Air as an example, and I'm making money hand over fist because I'm the only game in town, and I'm looking at, well, I don't want someone else to come in because that's going to impede on how much money I'm making. So I think there's 2 sides to this. I just am having a hard time understanding why we wouldn't do everything we can for consumers to provide them as much access to an optometrist as possible, and then also make sure that we do have those protections in there for consumers to make sure that they are being reported and protected. So I'm having a hard time understanding the opposition. And again, I'll be honest, I have not digested, I mean, this was dropped on us this morning, so I still need to go through it. But those are just some of my initial thoughts, probably more based on what we saw prior to today's meeting.
To one of your points on access, so I used to work at a community health center down in the Central Valley. So as rural in California as maybe you could get. And the vast majority of our patients there were either undocumented or on Medi-Cal. And as a practice owner now, or I should say as practice owners, we already have to decide whether it is good for us and good for our communities to even accept Medi-Cal. Those of us that do really do it from our hearts, right? It's not for money. It's not by any means a good business decision. So one concern we have is that, well, I picture someone, a savvy optometrist business owner, who wants to own multiple stores and make good business decisions by hiring more associates and moving into markets that are underserved. Maybe making savvy business decisions, such as not taking Medi-Cal or accepting Medi-Cal patients. So how does that affect access? Especially if those chains, for lack of a better word right now, put our smaller businesses, maybe the 1 or 2 that are already serving communities, out of business.
There's no guarantees that this is going to increase access to care. I think that's where we're coming from.
But it doesn't provide another option for access. I'm just asking. Access for care. But I had another question. I can't remember what it was as you were talking. Huh? It wasn't the recording. I can't remember. It'll come back to me. I was trying to think. You're talking about Central Valley. Yeah. Okay.
I just, on your comment to access to care, I mean, that there's still optometrists that are not going to even have an office in the locations where it's needed. I mean, that is a problem.
No, I know.
Yeah.
Oh, no, I know what it is. Do you know how many, and maybe Lillian, you know this, students coming out of school, recent graduates, how many of them are actually going and starting practices as opposed to going to work for someone? And how many of them eventually want to own their own practice? Or are there more and more optometrists who are looking towards working for someone as opposed to being the business owner? I don't know.
I just know that talking to my students right now, I will say the majority of them have a fair amount of debt. So the idea of owning a practice straight out, that's a pretty big financial step for them. So that's sort of something I think a lot of them are hoping to have later on down the road. But when you're coming out of school a couple $100,000 in debt, they're probably looking at working for someone first, and then with the vision of having their own practice later on.
Completely agree. I don't have any numbers. COA doesn't have those numbers handy right now. But I would say most students that I've interacted with have a goal of owning and running either a solo practice, but even more popular right now, a group practice. But to make that a reality, they are employed optometrists first.
And then my last question, how many offices, and you may not know this, maybe someone else does, can an ophthalmologist have?
As many as they want.
Okay.
Then I'll make a point to that. You're looking at all of these chain opticals coming in, and they have their practices within, the doctor's practice within, but of course, those are not optometric practices, they're ophthalmology corporations. So you have all of these ophthalmology corporations feeding the chain stores. And what oversight is there for us?
I'm sorry.
So we can't really control anything that's going on there, at least if optometrists are in charge of more locations and they have those reporting requirements. Don't we have a little more control over what our profession is doing and over the care our patients are getting, rather than just having them all going to the chain stores? And it's not optometry. I mean, it is, but it isn't. They've got this loophole going.
You're right, we can't control everything. Thing is, oversight or not, if this branch office law is repealed, it will mean more businesses operating in this manner. And from our perspective, that's still just harmful.
But there would be optometric offices with optometric ownership rather than ophthalmology ownership.
And enforcement's been a problem. I mean, we've had problems with enforcement in the past. We have problems with enforcement now with current laws, ability to deal with the practices that are out there now and the quality care issues. So, you know, I mean, I think we just have concerns. We're not opposed to expanding the law, but we have real concerns and we want to make sure we get this right.
I'm just afraid that we have such not a level playing field that we're allowing it to get away from us. Mm-hmm. And the only way we can compete is by being on that level playing field with the other companies. So, my 2 cents.
Okay. We have a comment for the public.
I just have to put a pause button in some of this just for a second for lens crafters who...
Who might you be?
Catherine Scott. That's very fair, thank you. I think I do this for a living again. Lens Crafters has been and had a relationship with this board, so out of respect for that relationship, we do have concerns with the bill, but related to the 17200 clause, which is the unfair competition clause. But we do believe we want to continue our work, so we're holding back our opposition to sit at the table and talk with folks. But I need to clarify a couple of things that have come up. Lens Crafters has been in the state for 20 plus years with only optometrists. We sat down with the stakeholders and worked through a regulatory model that allowed contracting of optometrists, and believe those optometrists will manage their practices based on their professional conduct. And we work with them every day to do that, and believe that is what should drive the bill, is related to professional conduct. We take and always have taken great exception at the concept that just because they're in a retail space, they're not providing a comprehensive eye exam. They have for years shown that they've given that comprehensive eye exam, and then there are 2 regulators that need to be mentioned. Every optometrist takes health insurance, and by taking health insurance, they have to meet the standards of care for DMHC and that health provider. And eye exam is a health provider. And if they take Medi-Cal, they have to meet the standards of care there as well. So we would just ask the board to consider that you regulate these optometrists every day, and that you'll be upholding that law as you consider how they conduct themselves, whether employed, contracted, or whatnot, with the patient. And the consumer at that point is what you need to consider. So if you're concerned, it should be concerned not about the business model and what it could force, not that I don't appreciate that, but it's really about what your optometrist, that your regulated optometrist is doing in their practice. And you're right. When we were working 684, the statistics showed that 50% of the optometrists don't want to be contract. They want to be employed. They don't want to start a contract. For every Kaiser position, there's 10 applications because they don't want to, it's an incredibly expensive model anymore to be a contractor. So for us, creating medical groups in other environments are very well utilized in other medical environments. It seems to us that, to your point, optometry should take a look at how they do that themselves. But really, at the end of the day, every single professional board judges the professional, not the relationship. And that's what you do. So for the purposes of consumer protection, we just actually think about that. But I did want to put a pause button on the difference and the contrast in the conversation around retail versus not retail, and just ask you to be thoughtful about that. Thank you.
Mr.
Mr. Maragami, I think we left off with you.
No, I have an additional comment, but I already made my comment, so I'll wait
I
until
know
you
what
go
the
around.
next
I'll
round.
go wait for the
You
next
looked
one.
like you were gonna come back with a comment.
I'm always like that, but I'll wait for the next
So,
one.
thank you, Dr. Turetsky.
I just find it kind of amusing that 47 other states really don't regulate how many offices an OD can have, but the 3 highly progressive states of California, Texas, and Oklahoma do regulate that. If I'm a physician, I can have unlimited office. If I'm a chiropractor, a dentist, a podiatrist. It really seems that it comes down to this overriding concern from the professional association that some evil individual is going to be selling $19 glasses and is going to put an optometrist potentially out of business or force him or her to have more competition. The laws that are here, especially what Senator McGuire has put in here as a protection measure, that you're responsible for the conduct of the people that you hire. I employ 23, 25 optometrists. I don't even know how many I employ right now. And we have systems in place to monitor their performance and ensure that they're providing a level of care which at a minimum meets or in most cases exceeds what's expected for the patients that we serve. I don't see what the problem is if we're going to open this up to 5 offices, 10 offices, 100 offices. I don't see what's wrong with having some protections thrown in there, modifying this in some way maybe, but that way you're ensuring for the association as well as the board that if somebody is misbehaving, doing 3-minute exams and just refracting and kicking somebody out, there's a mechanism to potentially hold the folks that employ that optometrist accountable. I just think it's time that we move on and open up the profession to provide greater access and also more competition. Competition is not a bad thing, and this law was originally devised with the statement that it was to prevent the evils of competition, correct?
That was an AG's opinion.
An AG's opinion, to prevent the evils of competition. It's time to get rid of it, or at least modify it a great deal. So those are my comments.
Thank you, Dr. Wong. Dr. Kawaguchi.
So I just want clarity on the COA's current position. It's oppose, period?
Oppose unless amended.
Okay. So there's already a demand out there. If there wasn't, then our cohorts, the MDs, wouldn't already be starting to change their models and how eye care is accessed. And my belief, and I believe it's the belief of the board as well, is that our responsibility to consumers is enforcement to both groups as well as individuals, and it depends on what's going on. And so, to Dr. Turetsky's point, it's the most important thing is to ensure that we have protections in place for consumers. I believe that we have protection in place for consumers because whether an optometrist works in a group setting or is under an owner that potentially could own multiple practices, they're still responsible for the quality of care that they provide. That's not going to ever go away. I do have concerns about the bill as currently written as well, but I believe that we'll be able to work through those things, and I look forward to the partnership.
And so, what I am recommending, because this is a topic that requires some thoughtful discussion and further interaction between the board and the public, that we stand up a work group, and perhaps Dr. Turetsky and Ms. Michelin could be on this work group since Dr. Wong and Mr. Morodomi are on the Mobile Clinic work group. Take this on and then report back to the Ledge Committee and then the board as a whole. What are your thoughts on that versus taking action today?
I mean, if they're willing, are you? She saw
I saw the look. I saw the look.
Sure. When do we have to When do we have?
So the hearing is Monday morning, and so the ask from the author's office is for the support letter and a commitment to work with stakeholders after this meeting to come up with a solution for patients. So the idea of the work group would to participate in those meetings.
So when the stakeholder meetings, they wouldn't be next week?
I have no promises. They could be next week.
I mean,
But the hearing is Monday.
I'm happy to help. I'm gone all next week.
Your thoughts?
No, I'm fine.
Okay.
I mean, if there's if you have meetings next week, maybe you want to have an alternate, because I can't do anything next week.
Okay.
I am on grandparent potential watch.
Do we have any alternates who might be interested in stepping up if there's...
Next week is just bad.
Would one of us need to appear at the committee hearing on the 23rd?
That would be great if one was able to participate on Monday.
To just be there or to testify?
Either or, whatever the will.
Well, it's not expected of anyone to change their schedule for Monday.
I will be there to testify whatever the board's position is. So I will be there.
So if I may ask that, if we were to like send you on a mission, what would you like us, what kind of direction would you like us to give you? I get do we support or not
Right.
the bill?
Yeah.
But things change daily. So what other kind of guidance could we give you to make you nimble?
And I want to add to that question because I think things have changed now that we're no longer the sponsor. Is that correct?
We're not the sponsor.
So we have less say
I know.
on what happens.
And I don't know if that's true. I think the McGuire's office is still really leaning on the board for guidance, even though we're not the sponsor. They assured me this morning that they still will lean heavily on us for our input.
Hence, not waiting, suggesting that we do a work group and let the senator's office know that.
What I would suggest is just have Jessica go on Monday, see what happens at the committee hearing.
There you go.
And then we can go from there. I mean, you kind of get a sense. I mean, I think we need to do a motion then, I guess, to support, if we're going to support it, take a position on the legislation so she can go and report back to the committee, this is our position on the bill, as it's written currently. And then once you sit through the committee hearing, we can come up with a plan of action of how to attack it after that. Because then you'll hear the input of other members of the committee as well, where I have no idea where they are on this. And I'm sure there are other people here that are talking to legislators, and and so we'll see what some of the questions are after the committee hearing. I think that's better than trying to anticipate what's going to happen.
Exactly, Mr. Moridomi.
So, my position is any change is a step forward, okay, to what we have now, which I do think is archaic. I hear concerns about the 17,200 provision. Would you say what someone has said, is it section 5 of the bill we have in front of us?
It is section 5, the newly amended section.
So, is that amendment of section 16780? Am I reading the right thing? What page are we talking about?
It's nice, 12. Look at the top, it says because the bottom all say 96. Yeah, not 12.
So it's section 5 at the bottom of page 12.
So the language really starts on page 13.
Yeah, you were right.
It's an addition to the business and professional
Okay,
code.
so let me understand, because I read this language and I thought, oh, that sounds pretty good to me. And it says, the person or entity shall not employ or contract with an optometrist in any setting in which the optometrist is subject to interference in the exercise of his or her professional judgment in treating a patient. Duh, right? And so I think the concern might be out there. The concern out there might be, oh, this subjects an entity or a company to a lawsuit. Okay, I understand the kind of institutional interest. You want to reduce the avenues of getting sued. But the purpose of this statute, of this amendment, seems like a good purpose to me. So if that's the bone of contention, as a board member, I'm in support of language like this because it enhances consumer protection. I can see why someone who might be sued under this might not like it, but I'm speaking as a board member. As I've listened to the discussion here, I'm speaking as a layperson, not as a Deputy Attorney General or counsel to this board, but as I look at this license, this statute, I'm concerned that it's unconstitutional. Maybe back in the day.
You mean the way it's currently written?
No, not this. The current law. The current law is unconstitutional. I hope I'm not making Nina jump out of her seat.
She's calm.
Maybe back in the day, there was concern of optometrists being unprofessional if they had a bunch of branch offices. But, I don't know if it was true back then. I mean, we've heard some testimony that, you got insurers regulating this, Medicare regulating this. Maybe the Board of Optometry was weak and feeble back in the day, but I don't think that's the case now. I think the argument, in a previous board meeting, I asked for the legislative history behind this, and there's a little bit about, patient protection, but not very much. I don't think there's an adequate legislative record supporting the consumer protection grounds for the original statute. So, I hear a lot of undercurrent of this is going to change competition in the field. And that runs smack into the antitrust concerns that the Supreme Court talked about, last year. So, speaking as a non-lawyer right now, I'm really concerned that the state could be sued over this.
Can I make a comment to that? So I think one of the concerns is that if you have 10, 12 practices, that becomes more of a money-making machine. And yes, you can comply with Medicare's guidelines of what's needed in an exam. There are so many shortcuts. I could do an exam in 10 minutes, and it could be a full exam, and it can fill all the requirements that Medicare requires. But is it a really good eye health exam, or am I just getting you in and out so I can get the next patient out so I can sell more glasses, or I can provide you with more products? So I think the concern also is that if you have so many offices, you are more concerned with the bottom. I mean, everyone's concerned with the bottom line, but how much more money can I make if I have a lot of offices, and then that may push out the independent practice owners who are actually providing really good quality eye care for offices that are providing full care, but maybe it's not really quality care. I mean, that's me playing devil's advocate.
Sure, but I still heard the pushing, when you push out the small owner, that's competition.
Right, that's competition. But I guess for consumer protection, that's competition, but then it's competition, and then you're not providing quality care to the consumers. Now you're providing them with not substandard, but it's just not as good.
But are we in the business of regulating what's not as good, or are we in the business of maintaining a standard of care?
Consumer protection. So my concern is if you have someone who owns 12 practices, they're trying to get in as many people as possible. That quality of care may not be
I'll counter you though. And I was talking with a COA trustee about this at the meeting the other day. And his concern was somebody could copy his business model, move down the street from him, and really hurt his business. And he's got himself set up right now, he's doing 4 exams an hour and pretty much moving everything out to his ancillary staff. So he goes in, checks the autorefractor results, does a quick slit lamp, doesn't even always dilate, he's doing an Optomap or something like that. And he spends most of his time, he said, just chatting with the patient. He said everything else is all automated. So he's doing 10, 15-minute eye exams, and he considers them to be top quality, excellent eye exams. And, you know, the guy who's doing the free eye exams next to ABC Optical and buying 2 pairs of glasses, at this point might still have half-hour time blocks to do whatever he wants to do with that patient. It really doesn't matter how many offices you have. It really doesn't matter where you practice. It really matters how you practice.
No, I agree. I guess my concern is if you have someone who has so many practices and I guess pushing out might be the wrong term in this conversation, but if it's forcing the people who are providing higher quality care, I guess it would be.
But then if you have some type of a consumer protection clause there where Dr. Kawaguchi is being told that, you know, if you've got time, go ahead and do ophthalmoscopy, but if not, just do the refraction and get him out. There's a recourse for him to say that he's being negatively impacted by ABC Optical or Dr. So-and-so to do this, and there's criminal consequences involved with that.
I guess I keep going back to what you just said. I mean, we're not here to, you know, do business plans for optometrists. You know, we're here, and I'm really having a hard time understanding the problem with if an optometrist wants to have a business model that they want to go into owning multiple practices or branch offices. You know, if they're not giving great care, then that actually, there's other options for people to go somewhere else. And that's competition. And sometimes competition raises the standard because, so I don't know. I don't know the answer, but that's what, I'm not hearing I'm hearing why it will affect optometrists and why it's detrimental to optometrists, which is, I totally can relate to that. What I'm not hearing is how this is really detrimental to patients and to consumers. Is there any data from, I mean, we've had disciplinary actions, you know, from optometrists who, like you said, you know, I mean, you're going to have bad apples anywhere. How, I don't know. I don't know what the answer is. I go back to the whole pocket license.
So
letting them practice where they want to practice.
So this discussion is really helpful. I mean, I get Member Wang's concern. I mean, I know of other medical professions where you bring the patient in and you can only spend 5 minutes with them, right? And it is a mill, and there is an effect on quality of care, even standard of care, because of the pressures. You know, there may be other ways of addressing that. I mean, do we want to have a rule that says you got to spend 30 minutes
No,
on the refraction,
I don't think it would make a difference.
right? Right? But I understand your concern, which actually makes me look at Section 5 again, that people are concerned about. I like this a lot now. I like this a lot. If the boss is saying, you know, spend 5 minutes per patient because, and I don't care about your professional judgment, I want that and be sued.
Yeah, but who's going to report them, I guess? So I guess my whole thing is also,
that's page 2. That's page 2.
Maybe I should be page 2.
I have a question on, Jessica, earlier you mentioned that there were some concerns by other, and what was that? Was it on this Section 5 as well?
So I supplied an opposition letter from National Vision, and first I was opposition unless amended. They opposed unless amended, and their specific concern was about the Section 5, and they outline in there the concern, and it's exactly what Mark Mordomi has spoke to. I know that there's other concerns. I don't know if Kat's able to speak to some of those concerns that they've relayed, but I think it's similar to what's in the opposition letter.
Yeah, I'm sorry, I apologize, I'm juggling two clients right now. I think our concerns are very similar to NBI's. The 17-200 concern that I can appreciate the intent of the law is to allow an attorney to act as a consumer advocate. But I think where we can best describe how 17-200 has been misused is when we look at the ADA cases and you walk in and hold several, I mean, you can't miss, all you have to do is put in ADA lawsuits and Dianne Feinstein spoke out against this type of abuse under 17-200. So while I appreciate the intent of the law, I think we would have to at some point ardently oppose the continued misuse of that law by law firms to line their pockets and not necessarily be interested in consumer harm. So I think just from a principle matter, we'd be concerned about that.
Law firms can have unlimited offices.
So just by the dynamic discussion we're having now, it requires additional input and consideration. So two things. Number one, there's action that is under consideration or guidance to give Jessica as she observes the meeting on Monday. And then to be able to pivot really quickly coming out of there, having a work group to go to start this and start the process to then take it to committee for additional action, because I would think after Monday, it's not going to be a clean cut, except here at the end, there's going to be some discussions, even compromise, et cetera.
Well, hopefully it'll be something that everybody dislikes, and then we know we've done a good job.
Could very well move in that direction, Dr. Turetsky, but let's hope that it doesn't and that we have done our job. And yeah, I'm just amazed that no one's brought up the whole reporting clause in here. So I
just have one other question. So when you're talking about stakeholder meetings, is that being called by the senator's office?
Yeah.
So they're taking the lead on
Yes.
all of that?
Yeah.
Okay.
So it'd be participation in thereof. So again, Jessica's asking for some type of guidance. We can either, someone can make a motion and we take a hard line, or she goes in saying, look, our board would like to stand up a working group, participate, and then you'll hear back.
I would motion that the president appoint a work group to work with stakeholders on this issue and help advance it in a format that works for all concerned.
I'd like to second that.
I have a question.
Discussion, question.
Shouldn't we also take a position on this legislation before us and say, we support? So I would amend your motion, if I can, to include all of that, plus we take a support position on the language before us now, and then we can always come back if it substantially changes and pull our support from the legislation.
Do you accept the friendly amendment?
I accept the friendly amendment.
Okay. Thank you. So let's call for the question, and then, yes, Madam Secretary, we need to take roll call.
Public comment?
Do you want to take
Yeah, no. So let's repeat back first what the motion is. Go ahead. So you're going to accept.
Okay, the motion is for the president to create a work group which will work in coordination with the executive officer and the stakeholders to find common ground to move forward on altering or amending the branch office license law. And in the meantime, the board it votes to accept the legislation as currently written.
No, take a support position.
Take a support position as currently written.
All right, so comments from the board, additional comments on that before we go to the public?
So I'm going to vote in favor of this, but to give my own expression of guidance to Jessica, right, my own personal, and that is, I understand and I'm considering the 17-200 concerns about making this into another ADA boondoggle, but there are ways of kind of tamping down those mill lawsuits. You know, we're not saying get rid of the ADA laws because of them. There are controls that are being considered and imposed, and I think those controls can probably be incorporated in this legislation if that's a concern.
60 days to correct a deficiency.
Something like that, right?
Yeah.
Smarter people can figure that out smarter than me. On the reporting, I don't care about the reporting, frankly, because I come from the extreme position as why do we have this branch office law in the first place? So, in my mind, you have all the flexibility you want on that reporting, because I don't care about it. So, I'm going to vote in favor of it, but those are my thoughts.
Any other, Dr. McIntyre, any other comments? No. Ms. Garcia, Ms. Murder, we heard, Michelin, Dr. Tretzky, Dr. Wong, Dr. Kawaguchi, Maria. Ms. Berger? No. Okay, comments from the public, please.
No, thank you.
Motion
We'll look
before
forward to
us?
working with you.
We're up.
Ms. Brandwein.
Aye.
Dr. Tretzky.
Aye.
Ms. Michelin, aye. Ms. Garcia.
Aye.
Dr. Kawaguchi.
Aye.
Dr. McIntyre.
Aye.
Mr. Mordani.
Aye.
Ms. Salazar-Sperber.
Abstain.
And Dr. Wong.
I'm going to abstain also.
Motion passes.
All right, thank you. All right, it's now noon
Lunch is
for a lunch break.
Oh, we're having lunch.
Is this,
No.
are they
Are we-
bringing
we're
in
going
for
there?
working?
Yeah, we're going there.
No, we're taking a break and going to dinner.
Okay, so we are now adjourning for lunch.
Can we leave computers in here?
This is going to be lost.
And we can now shut down the taping and.